We have three matters that we're going to hear together this afternoon: Hoehmann versus Town of Clarkstown, number 56, Borelli versus Town of Clarkstown, number 57, and matter of Jacobson versus Hoehmann, number 58. And Mr. Salkowicz, if I've got your name right, we're going to give you a bit more time than it shows on the sheet. So I'll save you, let's say, 3 minutes of rebuttal time, and we'll give you a little bit more time, just so it evens out more.
Thank you.
Yep.
May it please the court, I am Daniel Zalkowitz. I represent each of the respondents in the second department matters. The second department wrongfully ruled that the statute of limitations did not apply to the referendum issue that was raised by the plaintiffs in the underlying action. What ended up happening is 7 years after a law was enacted, the plaintiffs filed a lawsuit. There were two separate and distinct causes of action. The first one was that a mandatory referendum never took place, and the second cause of action related to the supermajority voting requirement. The Supreme Court properly ruled that the statute of limitations had expired because the referendum issue goes not to the heart of the law, but to the procedure in the way it was enacted. The third department in Rural Community Coalition...
I'm sorry. That assumes it was enacted in a way, right? But isn't the argument here that this is an inoperative law, so there is no enactment?
Well,
so how do you measure that from?
I measure that by the fact that the town board voted for it. It was sent up to Albany. It was placed in the town code. The whole purpose of initiating the lawsuit by the plaintiffs' appellants to begin with was because there was a law in the books that was enacted.
Well, there is an inoperative law in the books, in their view, because there's never been a vote by the people, and that vote is specifically reserved for the people by the home rule provision.
However, then you would need to reconcile that every single time there is a procedural infirmity.
It's not a procedural infirmity. So a procedural infirmity could be, you know, we're counting the votes in the legislative chamber, and we have a rule that you're required to write down each individual vote, and in this case we did a summary. That's a procedural problem. 4 years go by and nobody challenges that, you come in. This is, the law isn't effective under a statute because it requires a vote reserved for the people. Isn't that different than we didn't write down the names of each senator?
Except in order to get to that point, well, yes, of course that's different, but if you look at PNF, Tiffany props, if you look at the other mandatory referendum cases that were decided by all the appellate divisions across the board, they ruled that the challenge was too late anyway because the challenge to how the law comes into existence. Currently there's a law in existence in the town of Clarkstown. It's on the town code. Nobody says this law miraculously appeared there. Everyone knew how it got there. To then say, well, it wasn't properly enacted, which is really what the argument is. I understand the court saying that it wasn't enacted at all, but it's there. It got there somehow, and I would clearly define that as being enacted.
But so let's talk, what would you define as how would you say something's enacted? What's the
There
rule?
are steps in order to enact the law. I believe a law becomes enacted when it is filed in Albany and the local law is placed on the town books. At the end of every local law, it says enacted January 21st, 2021, or wherever it may be. In this case, it would be the same as the effective date.
So if there was never any vote in the town, no one ever voted for the law, but it just showed up and it says enacted, then you have 4 months to challenge that?
4 months or 6 years, depending on how the court looks at it, but I don't believe there's ever been a case, and I don't believe this is a case where nobody ever voted on it, it just showed up to date.
Do you have a working definition of what the difference is between a procedural requirement and something more than procedural?
Well, I don't. I believe that the Court of Appeals has one, and that's when it goes to the wit and wisdom of the law. I believe that these non-durational statute of limitations are when it actually goes to the constitutionality or the actual substance of the law itself. The procedural enactment is how the law has to get onto the books to begin with. Now, I would assume that if for some reason a law showed up in the town of Clarkstown, somebody there, either the town councilman, would actually initiate an Article 78 to begin with.
So it doesn't matter that there was no referendum in order for the law to be enacted? Is that what you're saying, despite?
At this juncture, 7 years later, it does not matter.
When I look at Home Rule Law 23, it seems to me to affect some very fundamental aspects of the citizens' relationship with their government. It talks about, changing terms or succession or vetoes or adopting a new charter. I have a hard time looking at those issues and calling them procedural. So how am I looking at this wrong? Can you readjust my perception on that?
Sure. Besides, obviously, the case law in the past, I think what it comes down to, the difference between procedural is actually who has the right to challenge a referendum requirement. I don't believe today every citizen of the town of Clarkstown has the right to challenge that requirement. The only people that would have standing to challenge under GIZA or any other case were people that resided in Clarkstown in 2014 when they were supposedly denied this right to have the referendum. And how can that then be something that affects the right of every citizen in the town of Clarkstown?
So if term limits, excuse me, Judge, but if they fundamentally change the nature of the government in Clarkstown after the 4-month period runs, just to be clear, you're saying that's it, it's too late, you're stuck with that?
Well, there is, obviously, there's laws that that legislatures enact all the time that the citizens don't agree with, and there's ways to go around doing that.
Well,
One,
it's
there
not
is a portal.
constitutional. I know you raised constitutionality as one of the valid non-procedural ways to attack the statute, but I don't know that this rises to constitutional dimension. But as I said, it fundamentally changes the nature of each.
And you can elect a town councilman that believes that term limits should be.
Well, I want to make sure that I understand your point. Are you saying that after the 4 months, nobody now could challenge the supermajority provision?
No,
That's
I'm
time
talking
barred?
about solely the referendum
Okay, so that there are
provision.
ways that, okay, right, so there are ways that the relationship between the town and its citizens can be fundamentally altered, that can be challenged by anybody at any time. Some ways.
The substance of the law itself,
Right, the
not how
substance.
it was enacted.
The substance of the law.
Yes.
Okay.
And so that's why I believe.
And that's, what you confuse me with standing, because
so-
anybody today would have standing to challenge the substance of the law, right?
But not the referendum provision. So if I was not a member of the town of Clarkstown in 2014 when the law was enacted, I moved, let's say, last year, I don't have the right to then say that, well, you denied me my right to a referendum in 2014. I had no ability to go there, and that's what GIZO stands for.
So when you say the substance can be challenged today, what exactly do you mean by that? Who could bring a challenge and to what exactly?
The way that the lawsuit was brought was under 2 causes of action. The first was that no referendum took place, so therefore the law is invalid, or whatever term you would like for it to say. That, I believe, is a challenge to the procedure, the mechanism in which this law was enacted. The second cause of action was to the supermajority voting requirement. I believe, and I believe that the Supreme Court agreed with me, that that could be deemed a valid challenge, except both the dissent at the Second Department and Judge Prieto at the Supreme Court level said that there is no issue having a supermajority voting requirement.
What would the remedy be if they won on the supermajority requirement?
The law would be, well, it would probably be the supermajority voting requirement would be deemed inactive, the law would stay in place, and I imagine.
So there is part of it, to Judge Wilson's question, that you can't challenge now.
But you can.
You'd only be challenging the supermajority provision.
Can I challenge term limits at this point?
Right.
No, but at the same time, if I was no longer a member, if I came here, once again, using the example, I moved to Clarkstown in 2020, 10, 20 years ago, a member of the board decided they wanted to do term limits, there was a referendum enacted, I'm still have the same issues. I still cannot challenge term limits.
But there's not a present challenge to term limits in this litigation.
There isn't.
There's not.
There is
It's
not.
just as to the supermajority provision.
It is.
So then, can you go to the merits of that?
So the supermajority provision relies on, or the challenge to it relies on a municipal home rule that says that any act has to be done by at least a majority of, the way that the plaintiff said by a majority of, and it's our position,
And the town law says something different.
the town law says 4-to-1 vote, supermajority. And it's our position.
No, I'm sorry, that's the local law.
Oh, I'm sorry.
It's majority plus
Town
one.
law 63 says that by a majority of the members.
So you have a difference in 2 statutes, one that says majority, one that says at least a majority, and how do we reconcile that?
I reconcile that's a floor, not a ceiling. That in order to look at municipal home rule 10, which says that the pretty much local town boards can rule the way they want to, this clearly goes to how a town board is going to have its governance, the voting requirement. That would mean then that the question is whether or not one town, this rule supersedes or is incompatible with both the municipal home rule or the town code. And because we're saying it's a floor, because it's
I
saying a
guess my
minimum.
question is, why do you think, if you have an explanation at all, that the legislature used 2 different wordings if they meant the same thing?
Well, I don't believe they meant the same thing. I believe that the municipal home rule relates to any sort of enactment that was in place. And I don't believe that by saying a majority, it means solely a majority. I believe that, obviously, the point is that two members of a board cannot rule. So to say,
No, I guess, let me ask it this way. Suppose both statutes said at least a majority. Would there be any difference in meaning to the way it reads now?
no, I don't believe so. It'd obviously be clearer, but I don't believe that it would be any different. And then the real question, though, is that a state legislator intend to tell the town of Clarkstown board how they can repeal a law, by what vote power? And I don't believe there's anything to ever indicate that the state intend to supersede or to make any ruling over how town boards can
So
do
what
any
if,
rule.
what if the town board said that the supermajority provision, sorry, that the term limit provision can't be repealed at all?
Then, but so, and then the question is whether or not that violates, I don't believe it would under the law.
That wouldn't violate the majority provision.
That's correct.
So they'd be free to do that, too.
They would be free to do that.
And under your theory, nobody could ever challenge that after 4 months had run, is that right?
The challenge, well, they could continuously challenge that part of it because we're not talking about the referendum. I believe that it's very important to segregate out the two causes of action. The same way that, what I said below, if I was to sue somebody for a breach of contract claim 5 years out and also include a defamation claim that was outside of statute of limitations, you don't have the ability to bring in the statute of limitations that expired. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Robert Spalzino, and I represent the respondent in the first proceeding today. The law at issue here is not effective today, was not effective yesterday or 8 years ago, because it was never enacted. The municipal home rule law requires 2 steps for the law to be enacted, and it specifically provides that if those 2 steps don't occur, the law is inoperative.
Why aren't those procedural steps?
Because they go not to the way in which the law was enacted, they go to whether it was enacted at all. I'm sorry, Judge
Well,
Wilson.
I mean, but any defect in the procedure by which a law is enacted arguably renders the law invalid. No?
It renders it, well, let me back up. I believe that this procedural substantive dichotomy, which, as you probably know, I was involved in developing, has run into a dead end. It's run into the case that nobody anticipated. The other aspects of the law, the procedural things, are steps that you take in enacting, in taking the act that creates the law.
So what would that include, for example?
Sending out notice, having a public hearing, following seeker if there was a seeker, if the law required seeker compliance, things like that, those steps. But they don't include the vote of the town board, for
Why?
example.
Well, why doesn't it include the procedure to set up the referendum, which of course never happened?
Because there's a distinction between the act itself and the procedural steps that are necessary to take that act.
The act, you mean the law?
I'm sorry?
The act, you mean the statute, the law?
Right.
Okay.
If the town board never voted, nobody would be here saying this law was valid. In this kind of a law, two
What if
steps.
the town never voted and it was put to a referendum and the people adopted it?
It would still be invalid.
And you would say that there's no statute of limitations to challenge it?
Correct. I'm not sure how that would happen.
You could
but
go 100 years and, well, it might, right?
I
The
don't.
chair forgot to call a vote, and there wasn't a vote taken, and the minutes didn't reflect it, but they sent it out for referendum, and,
I
I mean, I'm
guess
not
that's
sure how
con-
this happened.
I guess that's conceivable, Judge Wilson. But here, there's no dispute. The referendum, one of the 2 acts that's necessary to make this law a law, never happened.
Is there a time limit on when you can hold a referendum after the law is passed by the government?
My recollection is that it's a complicated process depending upon when you enact the law or when the town board acts in relation to when the next election is. If it's so many days before the election, you have to put it on the general election. If it's so many days after, something like that.
There are
That's what-
time limits.
There are time limits, and that's what defines
And
it.
so if I understand you correctly, when you say we've sort of run into a dead end here in terms of what the law anticipated, you're in some ways advocating a third category. That is, this isn't really substantive, and it's not procedural, it's something else.
That's right. If it's,
Because, I mean,
of
you'd
course-
agree, right, that it has, the question of whether there was a referendum or not it's completely agnostic to what the substance of this law was. It could have been about fishing just as easily as, right?
Well, although you probably wouldn't need a mandatory referendum on a fishing law. But that's the point. That I think what happens is, and respectfully this happens with judicial drift at all courts, is that you try to find the defining principle, which is what the PNN Tiffany case did, and say, well, there's procedural and there's substantive. And then then something comes up that doesn't fit neatly into those categories. I mean, you could define substantive as including the acts themselves, but that's probably not what was generally meant by substantive. What was meant by substantive was some sort of invalidity, such as the noncompliance with Section 63 of the town law and the municipal home rule, and was procedural, at least in those cases, was defined by steps.
What is it that makes this not neatly fitting into the category of either procedural or substantive? Is it something specific to the nature of referendums, or because the only point of reference I have is SEQR review, and I'm trying to understand what distinguishes what happened in that case versus what's happening in this case.
Well, in SEQR, in the SEQR cases, in this case the Court of Appeals decided on this issue, the law itself was still voted on. The legislative body didn't do one of the things that it had to do in order to do that, but it still voted on the law. And this is where I think the distinction is, okay? The other cases had to do with sending out notice.
Some voting act? So, because I'm trying to craft a rule off of your argument. Could we say that it's that category of cases that resides with one foot in both procedural and substantive would be the ones that require referenda? Or is it broader than that or narrower than that?
It may. I'd have to go back and look at the entire list, so I can't say specifically. But I think it's not. I think when you talk about substance, we're generally talking about what the words are and what the words do. We're not talking about how the law came to be. We're more closer is in talking about how the law came to be is the procedural steps. But the distinction between procedure and what's at issue here is that none of those steps that have been found to be procedural and therefore subject to the 4-month statute of limitations involve doing the deed itself. They're things that should have been done in order to do the deed, the enactment of the law, but they're not the enactment of the law itself. The referendum is an integral part. It's one of the two acts that the statute defines as having to occur. It's arguably the more important one because it's...
So then, under your analysis, there's no need to consider whether or not there's a continuing harm?
Well, I think the answer is that this is a continuing harm in the sense that the law is invalid today. The law was never enacted. This lawsuit seeks a declaration that the law was never enacted. It's not operative, it's not effective, it's unenforceable because it never was. And that's true today. It was true 6 years ago. It's true.
But the reason for that is a particular step is not followed, and then we're back to whether or not that step goes to the procedural aspects or perhaps some substantive aspects.
And that's,
But who is harmed in your view?
I think,
Or what?
I think the people who didn't get to vote for it are harmed
Originally?
originally. I think the people who don't get to vote for a candidate today,
How
who they
is it
might like to...
continuing, though?
What's that?
When you say continuing, what do you mean by that? Who's it continuing to harm?
It's continuing to harm the voters of the electors of the town of
Does it have to be
Clarkstown.
the same set of voters?
Respectfully, I would say no. They are all being harmed because a law that doesn't exist is being applied to bar a person from running for office that they might want
What
to,
about
the
the
voters might
town
want to
board?
choose.
What about the town board and the person who doesn't want to be term limited?
Town
Are
board
they
members.
harmed? in a particular way that's relevant to the analysis? Or are we
Sure.
only looking at voters?
No, town board members, candidates, the town board members who would be subject to this are harmed.
So some.
And if we conclude, if we conclude that continuing harm theory doctrine, we don't accept it, does it matter what the statute of limitations is in this case, whether it's 4 months or 6 years?
Well, in
Does
the
that
sense that
become relevant?
in the sense that the lawsuit was brought more than 6 years, in that sense, it doesn't matter. But I would suggest, Judge Singas, that the law a law that's not enacted can't be barred. A lawsuit to declare a law that was not enacted can't be barred by a statute of limitations.
That's what,
That would,
go ahead.
that would allow a law to come into existence merely by the passage of time without the votes of the people who had to vote on it.
So that's what I'm struggling with. Is your position that continuing harm has to be shown, but that there is continuing harm necessarily demonstrated into the forever future because your argument is the law was never duly enacted?
Yes.
Okay.
The law-
And why exactly is it that that's true here as opposed to the more conventional analysis of continuing harm where I have to show that something is, accruing day after day, time after time?
Well, because it is accruing time after time, it's applying every day. It's enforcing a law that was never enacted. If a law barring theft had never been
Isn't that the
enacted.
same outcome if you just have a law that didn't follow the proper procedure, but the time runs out? Now it's on the books and people are subject to it.
Because the procedural steps are different, respectfully, Judge Rivera, than the act itself.
The difficulty I'm having, from a sort of policy point of view, is that there is a purpose behind statute of limitations, and some of that has to do with the loss of information over time. And at least as, so if you have, now we're talking about continuing injury, but unless a statute has absolutely no practical application today, that nobody cares about, it doesn't affect anybody, a statute is always going to have some continuing harm in the sense you mean it, which really means that a statute was enacted 150 years ago. If somebody can go back and prove that, let's say, there was no referendum or the vote didn't occur that was supposed to occur, that can be wiped off the books, even though people have been abiding by that statute and expect that it exists, which seems a little unorthodox.
Well, I think the situation's unorthodox, Judge Wilson. I don't think this happens a lot. I don't even know there's any precedent on this. But it goes back to the fact, without regard to or even after taking into consideration the policy concerns that you're raising, that the act never happened, the law was never adopted, so how can you enforce it? If there was no law against theft and someone tried to prosecute someone for theft, I don't think you'd say, oh, well, we can prosecute you because it's been on the books for a long time, if the legislature had never adopted it. That's the situation here. The legislative body never adopted this law. I shouldn't say that. The voters never adopted this law. They had one of the two integral steps here was theirs. It never happened. The law is invalid, and therefore the law is invalid because it never was enacted, not because of some procedural step.
Why
because it
isn't
never
that really a
happened.
constitutional claim that hasn't been made?
Well,
Isn't that really about a constitutional problem?
I think it's akin to a
You
constitutional claim.
can't have a law on the books that hasn't been enacted in a particular way as a constitutional matter. So that
Well-
really resonates with me, that's what it sounds like you're really arguing.
I agree that it is akin to a constitutional matter, that you can't, that laws require, laws don't get enacted without being enacted. Laws can't be enforced without being enacted. The more immediate claim, though, is that the procedure here is defined by the legislature of the Municipal Home Rule Law, and that's why we're relying on the Municipal Home Rule Law as the standard. The Constitution says,
Look, one way, and I'm having trouble fitting this into this, as you say, this procedural substantive framework, is this is so different because in that case where you have a procedural requirement, it seems to me that the people have delegated that authority to set that process to the legislature. In this case, the people, through their state representatives, have retained the authority to vote on this. So it's not the process that they've delegated and then it becomes a government action and a process in enacting the law that they challenge, whether by a legislative body or delegated to an executive agency, but it is the retained power of the people to vote. And that seems to be not to fit into a procedural framework at all.
I agree, and perhaps the category you were looking for, Judge Garcia, earlier, is if the people have to vote on it and the people don't vote on it, it ain't law. And that's the situation here. That's why it's different than any of those procedural steps. If you're talking about seeker or notice or things like that,
But the point, I
those are
think, is a
things-
little bit more fundamental than that. It's those things you've all delegated to either the legislature or an agency to do. And if they don't do them, there are procedural steps they have to take. You can challenge that in a certain way. But this was a power that through the representatives in Albany, the people retained. And that was to vote on this. And that, to me, doesn't seem like a procedural step subject to an Article 78 proceeding.
I think that's correct. And just to go a little bit further, those other things are things that one might decide are not worth litigating about because they missed some notice step or they missed some procedure step, or could. But no one out there can absolve the process, if you will, of not having the people vote when the people are entitled to vote. That's the bottom line here as far as I'm concerned. It doesn't, the non-enacted law doesn't magically become an enacted law by the passage of time. And that's the fundamental argument here.
Thank you.
Thank you.
Good afternoon. I'm Kevin Conway. I'm the Deputy Town Attorney for the Town of Clarkstown. I have a slightly different perspective, but I'd like to start where Council finished. I had argued at the oral argument for the Appellate Division, and the Court picked up on it, and they put it in their decision, the sanctity of the right to vote. That's really what's at issue here. So whether we talk about procedural versus substantive, on the constitutional side...
I'm sorry, which right to vote are you talking about? The right to vote for the candidate of your choice or the right to vote for the enactment of a town law?
Both in this case, because, and the Court picked up on it in the decision. They said rather it affected the rights of the future members of the town board, that's one issue, and the public, and the sanctity of the right to vote. Because what took place back in 2014, the law was passed, but without public referendum. When we were in front of Judge Puerto, she ruled that the statute, a 4-month statute applied, and she threw in a paragraph saying that the law was passed on a valid basis by a simple majority, but she ignored Rule 23, which has mandatory, if you're going to shorten or lengthen an elected term of office, the public has the right to rule on that. The public may have determined that they didn't want term limits. They may have determined that they did. The other thing, that when that law was passed on an invalid basis, they failed as the local town board to declare that they were going to supersede the town law 63 and put in the supermajority requirement. So there's two problems with this law. The biggest, to me, it's a voting rights issue that the public never got to weigh in. And the public now, since this whole case started, is very confused because term limits was upheld. Term limits was then repealed because before Judge Puerto decided this case, the town board met, realized the invalidity of the law, and repealed it on a simple majority vote. They went back to Judge Puerto and said, put the bad law back on the books, and she did. The Appellate Division agreed with my position that it was bad law, it was invalidly passed, it should be stricken, it was, and now they're back here again before this panel to say, put the bad law back on the books a second time.
When the town board repealed the law recently, did they put that to a referendum?
No, they, by simple majority, because it was already as a current law.
Well, they were changing the term limits again when they repealed the prior law.
They weren't, they just repealed it because they saw that it was an invalidly passed law in the first place. So that was their basis, because they had a
But under
3-hour
Home Rule
hearing.
23, I think this might be what Chief Judge Wilson is referring to. Under Home Rule 23, a law that changes a term of office is a mandatory subject of referendum. So wouldn't the repeal suffer from the same infirmity as the original enactment?
No, because they recognized in the public hearing, which was about 2 to 3 hours, everyone spoke, members of the public, they specifically referenced the invalidity of the underlying law. And when we were before the appellate division, invalid laws are struck down all the time. That's not unusual, and every department, including the Court of Appeals, has invalidated laws at various times. So that's not so unusual that it can never be done, because that's what the appellants wish this court to take the position.
Irrespective of whether or not the claim is subject to a statute of limitations?
Yes, and I haven't seen anything that says an invalid law stays in the books forever even with regard to statute of limitations.
I don't know that you're going to get a judge saying that.
No, but here-
in terms of the cases that you're referring to, do they involve claims that have gone on, have been asserted many, many years after the law has been enacted?
There was no statute of limitations issue. This case is kind of unique,
Yes.
and for a lot of reasons. But no, not specifically with regard to the statute. But again, it smacks of more substantive, and because it deals with voting rights. And when you look at Home Rule 23, it's so basic that there's 5 or 6 categories, including this one, where you must, not permissive, you have the option,
I mean,
mandatory,
when you
must
say
have
substantive because it deals with voting rights, it seems to me you're trying to make a classification about importance as equivalent to substantive. And at least on a substantive procedural dichotomy, that's not the way I think about right?
No, and I would say when I first became involved in the case, it is very unusual, but as the more time one spends on it, you tend to come to that conclusion, that it was passed invalidly on 2 bases, not declaring the supermajority provision and not having, the bigger issue is not having the public having the opportunity to vote, and they still don't. And they watched this roller coaster ride go on from when this case started to where we are now. And
Well, but I think there's no question the supermajority provision can be challenged now, right?
well, I think it was challenged and it was dismissed. It was repealed.
That's a legislative action. I mean, the courts consider, I don't think that anyone's arguing that the statute of limitations bars us from considering the proper interpretation of the town law and the municipal home rule law.
No, and this court could rule with regard to, not the first part of the case, and the appellate division had the option to rule on the latter part of the case that, you know what, the town repealed it, they had the ability to, so that's the end of it. They could have done that. They didn't. This court still could, because my position is there's no restriction or time bar on the repeal of it, and it was repealed.
So
And it's
to-
appropriate for the legislature to
It
do
Go to
was
that.
that-
properly repealed even though it wasn't a majority plus 1.
Correct.
And I'm still not sure I understand why you think that requirement doesn't apply to the repeal of a referendum, I mean.
If it had been a valid law and validly passed with the supermajority provision, then I would agree, but it wasn't, and we know it wasn't for 2 reasons. And
But it seems to me that the members of the board or the community, I'm not sure that they can make a determination about whether the law has legal validity. It seems to me probably a court has to do that. So how is it that their view that the law was, if I'm understanding you, that the law was invalid, why does that enable them to then disregard the referendum requirement?
because the supermajority provision wasn't properly passed the first time. Had the referendum been done and had the public voted for it, had they declared themselves almost as lead agency saying we're going to preempt State Law 63 by having supermajority provision in this law, including term limits, then I would agree. But they didn't do either. So there's nothing to prevent the legislature from curing, just like courts can
But
cure.
what are you curing? If it's invalid, what are you repealing?
They were repealing the law that was on the
But
books.
if it's invalid, I mean, I think this is in part what Judge Garcia was asking about before, and the argument that's being made is not a proper enactment, so what are you repealing? Don't you have to repeal a properly enacted law? The exercise of repealing is because you're trying to abolish the authority that goes behind the original enactment.
Well, you're repealing the improperly enacted or invalid law, And that's what the legislature has the ability to enact, and they have the ability to repeal. The courts have the ability, just like the appellate division, they distinguish the other decisions. They have the ability to knock out a prior decision or distinguish. It's the normal process. It's not the end of the world from the appellant's view if that were to happen. It's normal.
Do you know sort of what's the window now for the Board of Elections? I mean, to
Oh,
make sure they have whatever decision they need to be able to proceed?
yeah, no, that process is still
Primary?
ongoing because the parties that wish to, and Mr. Garvey can speak to the candidate Hoehmann and perhaps the other candidates, but parties that wish to run carried petitions and did so. Parties that didn't wish to did not. And interestingly,
But in terms of printing up the ballots and absentee ballots and knowing what names to have on them, what's their window for that?
no, that's already been done, so I believe his candidate already has that done, so that won't be affected as a practical matter by this court's decision. And it's been very expedited up to now.
Doesn't that
including-
depend on what the decision is?
What's
Yeah.
that?
Doesn't that, I mean, do they have to reprint the ballots perhaps?
No, I don't know that if that's the case. If they do, they do, but that's a small, that should be, the practical side, in my opinion, shouldn't matter.
Are you saying our decision in this case, even if it were issued this afternoon, would be academic?
No, what I'm saying is I don't think that part I can't speak to, but I don't think that should be a consideration, or that as a consideration would make a difference with regard to the legal issues we're discussing, that's all. So my perspective is, it was an invalid law when it was first passed, the voters
But it's
got
not really an
shortchanged.
invalid law, right? I mean, it's an inoperative law. It's not invalid. They didn't do anything wrong by doing what they did. They just didn't do the next thing to make it operative. So how does that affect our analysis?
Because
It's not invalid.
Oh, because the voters didn't get their say. That's the big difference. And this is such an important issue, which the cases talk about binding future boards to what they can do or can't do, and binding the voters to what they can or can't do. That's to me, is the real issue in the case. Thank you.
Thank you.
Thank you. May it please the court, my name is Lawrence Garvey, and I am the attorney for Mr. Hoehmann, the respondent here today on the Article 16 election law action. If I could answer the court's first question about timing of the ballots, it's my understanding, I can't make an absolute representation of this, it's my understanding that, at least in Rockland County, in our Board of Elections, they are waiting for this decision, because this is the only thing that's holding up the ballot. They had some deadlines this week, but they have some room to adjust, all right? But they are waiting for this decision.
So but you don't know how much time, what that window is? We
I know-
all assume this is not a 3-week
No, it's
process
days.
on our side.
It's days, Your Honor, that's my understanding, yes, correct.
Okay.
And I don't really have a whole lot to add that what we've seen here, except a thought just occurred to me that one of the questions was, you know, is it operative, is it non-operative? And it is operative today because Mr. Hoehmann was thrown off the ballot essentially because of this law. It's the first time it was interpreted, it was the first time it was applied, it was the first time
I
it was...
mean, legally inoperative, because we've said that before, that if you don't do the referendum process, then it's an inoperative law, waiting to become operative, meaning it shouldn't have any effect.
But it did have an effect, and that is that Mr. Hoehmann was not allowed to remain on the ballot.
That's what we're here to determine,
No, I know,
isn't it?
yes,
Right.
right. I just wanted to make that clarification, and I'm happy to answer any other questions if the court has them. Thank you.
Thank you.
I think briefly, the concept that the voters were retained the authority to vote on this statute. The question when it comes to statute of limitations, as the Court of Appeals has always held, is could have this been determined within an applicable timeframe? Let's assume the court said this is in Article 78, but should have been done under declaratory judgment. That would leave a 6-year statute of limitation. The thought that this only became in effect because Mr. Hoehmann is about to be term limited out, I would argue that it came into effect once he was elected to his second term, because at that point, he knew he could never run for another office. That was within the 6 years of the statute of limitations. It could have been brought at that point in time. what the appellant's counsel said was the procedure is defined by the municipal home rule law. Again, we use that phrase procedure. There's a process for something to take place. The concept of the public hearing, there was a public hearing when this law was enacted. Nothing was done secretive. I think it's important to think, though, about the broad spectrum implications of this decision, because there are multiple other second department, third department decisions that talk about the validity of, or the timing to challenge when an actual referendum was required to be held. At this point, according to anyone's interpretation on the respondent side, I guess, at this level, you can just ignore the law. You can do whatever you'd like, or now any law can be challenged because an action, the referendum did not come into play. If there's no further questions, thank you.
Thank you.